So this is just a brief discussion about a recent case that we handled called the Tacoma South Hospitality LLC case versus Integon Insurance. And this case came to us actually kind of in a unique way. The plaintiff ended up filing a lawsuit against an insured's insurance company. So the background of this case was Integon's insureds was traveling out of state and was up in the Tacoma area staying at a hotel that was owned by Tacoma South Hospitality LLC. And this was during a terrible snowstorm that hit the Tacoma area several years back. And the insured actually pulled into the parking lot for the hotel, slid on ice, and damaged the hotel's sign. So there was damage caused to the insured's vehicle and also to the insured's sign. Relatively low dollar amount, under $15,000 of total damages, but the plaintiff, the hotel in this case, brought a claim against the insured, and there was some settlement negotiations, including a settlement offer that was made for less than the total amount of the damages. The plaintiff, who at that time was actually represented by an attorney, rejected the insurance company's offer of settlement, and the plaintiff took that opportunity to say that it was the plaintiff's attorney's belief that the insurance company had somehow violated rules in Washington for insurance fair conduct, the Consumer Protection Act, and various other statutes giving rise to a claim directly against the insurance company. So it was interesting that in this case, the claim wasn't actually ever asserted at the driver of the vehicle, but rather the way the driver's insurance company handled the claim when they made offers to settle the claim. The plaintiff and their attorney in this case was very aggressive in motion practice. They tried to do various different things, including a very broad discovery against the insurance company. They also were trying to make allegations that the method of the claims handling gave rise to bad faith, violated the Consumer Protection Act, all of which had their own triggers for potential attorney fees and other sanction type damages. And then at one point they actually even sought to certify the case as a class action to try to turn this relatively low dollar claim into a class action against the insurance company. So our response to the case really was to focus on what was giving rise to this action, in this case a relatively minor car accident, that actually the hotel, the plaintiff in this case, actually had some responsibility for. Remember that this accident happened because the hotel had allowed their parking lot to become icy during a snowstorm, and that's actually what led to the insured sliding into the sign. So our argument continued to be that the plaintiff itself had some responsibility for this accident as well, as they would have under a comparative fault theory if they had actually brought claims against the insured. But again, they didn't ever make any claim against the insured. Instead, what they were focusing on was basically the insurance company's, what they said was bad handling of the property damage claim. So they brought a huge number of motions. There was more than 10 motions that were brought through the course of the litigation in this case. They tried to move to quash our subpoena to depose witnesses. They tried to move to compel discovery that it was our position was just outside the scope of the issues in the case. Bunch of different motion practice, including multiple motions for summary judgment or partial summary judgment. And of course, I think the strategy there was just keep us working on motion after motion and motion, and kind of try to drown us in paper. Well, of course, that didn't work. We've had enough resources to respond appropriately to all the motion practice and actually focus on the real issues in the case, which was whether or not they could even meet their obligation to provide a claim against the insurance company under these very interesting and convoluted circumstances. We filed our motion for summary judgment several months into the case after we had done what we thought was this discovery we needed to support it. We filed our motion for summary judgment, and the court ended up granting that motion and basically finding that there was no issue of material fact in the case with regard to the claims that were alleged by the plaintiff in this case against the insurance company. So when we won the motion for summary judgment, the plaintiff's attorney in this case ended up filing an appeal, and we responded appropriately to the appeal. And as part of our appeal, we actually asked for sanctions associated with the appeal because we felt that the basis of the appeal was no better than really the basis of the claims that were asserted in the underlying case. And the Court of Appeals found for us and actually awarded sanctions, including our attorney fees on the appeal. The plaintiff and their lawyer then actually tried to seek review by the Washington Supreme Court. That was denied, and ultimately we prevailed on the case, including an award of our attorney fees on appeal. So great success, and at the end of the day, the focus that we had was really the underlying facts in the case, and that there wasn't any specific claim that would give rise to the complaint that was ultimately filed. And at the end of the day, we were right, and the Court of Appeals agreed with that.